Welcome back to Advocates for Justice Paralegal Service. And I just want to say that I'm the Director of Advocates for Justice, and I approve this message. So we specialize in foreclosure defense, third-party debt collections, and a few other things. But right now we're focusing on foreclosure defense. Um, Today we're going to talk about a couple of things. It's going to be a short video. One of the most important things homeowners get wrong when they're fighting foreclosure. And we're also going to give a couple of tips. But before we get into all that, I want to ask you guys to subscribe to my YouTube channel, like and share. Your subscriptions to my channel will help me help other families who are fighting foreclosure, who are struggling with income, and also help me feed my puppy. I have a golden doodle, and she eats a lot of really expensive stuff. So if you guys could like and share, even if you're not facing foreclosure, okay? Even if you're not facing foreclosure, please go ahead and subscribe to my YouTube channel and help me qualify to get in the YouTube partnership program where I can host ads on my site. And once I'm able to do that, things will be a lot different around here. Anyway, so let's just get into it. One of the most important things homeowners get wrong when they're fighting foreclosure or filing a wrong foreclosure lawsuit is they do not list the name of the person who actually initiated the foreclosure against their property as the number one defendant. And most people just follow the attorney's lead and place the lender as the number one defendant because that's what the attorney said to do, okay? But we all know attorneys are the ones that structured the foreclosure defense strategies that we're currently using, and they're not helping anybody, okay? When you're getting ready to fight your foreclosure, the number one thing that you should be looking for is the signatures on the foreclosure lawsuit petition that was filed against you, okay? Who signed that petition against your property? That is the person that should be at the number one position on the defendant list of your lawsuit, okay? Whoever signed to initiate the lawsuit against your property, that is the person that you should be holding liable in court. And in a judicial foreclosure, there's only one signature on the lawsuit, on the petition, and that's the signature of the attorney. I have not once seen the signature from any agents from the bank or the bank vice president or president or anybody. It's only the attorneys. And you know what? The attorneys never file in court anything to verify agency. So, maybe the attorneys are the ones that are doing the illegal foreclosures against people's property, and the bank's waiting in the corners for the property itself for a loss so they can claim it on the mortgage insurance. I wonder if that could be the case. Let's think about it. And in a non-judicial foreclosure, the document that you would want to take a look at is the notice of default letter or the notice of acceleration letter or whatever that letter is. Different states call it different things. That letter that notice of default letter is used to execute the power of sale clause in a deed of trust. So pretty much that letter is what initiates the foreclosure proceedings against your property. Now, who signs that letter? If you go check, if you're in a non-judicial foreclosure, go check. Check that notice of default letter. I would bet you 25 cents it's signed by the attorney that's initiating the foreclosure. Yep. And that's a fatal flaw to the foreclosure that they file against your property, because that notice of default letter is supposed to be signed by one person, that is the trustee. And the trustees never signs it from what I have seen in the last, in all the years that I've been helping people. It's always signed by the attorney who is initiating the foreclosure. In one of my foreclosure defense strategies, we teach homeowners how to list their attorney as the number one defendant and their law firm as the second defendant in their lawsuit. And we only add the last servicer, and we leave all the rest of those other corporations off because they already made their money from the property, and they're not the ones attacking your property right now. Okay, so we don't worry about listing a whole bunch of all that does is complicate the whole process for you. And I think attorneys do that on purpose so that it'll steal people's hope. It'll steal your hope and you'll feel like you don't have a chance. If you don't have the right party as a number one defendant, you're doomed from the gate. So this is very important. You need to make sure that you go by the signatures on your paperwork to figure out who should be the number one defendant in your lawsuit, and not what attorneys have led us to believe for years, because most of that stuff that attorneys led us to believe is not true. So let's get on to the tip of the day. Homeowners' lawful challenge, okay? Homeowners must demand that the injured party appear in court and in court to state his or her injuries on the record, okay? If the injured party cannot attend the court hearing, the case should be dismissed, because the Sixth Amendment secures that no person will be deprived of life, liberty, or property without due process of law. And I think that the non-judicial foreclosure proceedings is totally in violation of the Sixth Amendment, because they're taking your property without even allowing you an opportunity to get into court. I don't understand how that rolls, but we have a plan for it. And our plan that we have for the non-judicial foreclosure process actually blocks the eviction process, okay, at the gate, in the beginning. And that plan was very carefully structured. A lot of research went into how to figure that out. And the way we do that is that in a non-judicial foreclosure, okay, the whole process is done outside of court and once the foreclosure process is complete and they sell your house, then they move into a lower court to do the eviction process. And the problem with that, it's also sketchy, but the problem with that is in the eviction court can only make a determination, they can only make a ruling on immediate possession, okay? So they can't make a ruling on title dispute because they do not have jurisdiction to rule on title dispute. Most people don't understand that or know that or understand that. So they go into eviction court with all their paperwork, arguing all of these things, okay, about the title dispute, and the judge ignores you. And they'll tell you right out, we can't hear that. Now, what should happen, in my opinion, is that once you start arguing a title dispute, it should get moved over to a court that can make a determination on the title dispute. Or wait, maybe that's where it should be in the first place. But this whole process is really sketchy because they know we don't understand these things, and it gives them a chance to get a leg up on us, okay? So when you file your wrongful foreclosure lawsuit in federal court, you're creating your title dispute. And our lawsuit package, our non-judicial lawsuit package has, I don't know, 9 or 10 documents in it. And it has the documents that you need to challenge the eviction court's jurisdiction. It has documents you need to remove your case from eviction court over to federal court where your title dispute is at, and have it connected with the title dispute. And once you do that, you ask federal court to make the title dispute mute, make the immediate possession mute until the title dispute has been determined, has been settled. Because at the end of the day, the immediate possession takes a back seat to the title dispute, because you can't figure out who should get immediate possession if there's a title dispute. You got to do the title dispute first, okay? So keep that in mind. An injured party must appear and state that he or she is owed a debt, and the debtor must be given the right to challenge the debt for validation under 15 U.S.C. 1692G. Only an injured party can claim a debt is owed. Imaginary persons cannot appear or give testimony and cannot be the plaintiff of a cause of action. The attorney is acting as a foreign agent for a foreign state, corporation, who has commenced the foreclosure action in violation of the 11th Amendment and in violation of 22 U.S.C. 611. Homeowners should demand the foreclosure case be dismissed and all the documents to be stricken from the record. If you're facing foreclosure and you're ready to attack your foreclosure using non-conventional strategies, go to my website and invest in your wrongful foreclosure lawsuit package, or your judicial wrongful foreclosure lawsuit package, and review the documents. Highlight any areas where you have questions, and then go to my website and schedule a support session. And I will get on the phone with you and answer all your questions. You have to make sure you understand what you have before you go and file it, okay? Because if you don't, they'll ask you questions and they'll start picking at you. And if you don't do a very good job of answering the questions when the clerk's picking at you, then they're going to start sending you on a runaround and telling you, you need to do this, you need to do that, and do all these other things, okay? This week, we've had 3 law firms request to join our private Facebook group. It's called Foreclosure Rescue. And it's interesting that these attorneys want to join my group. And the reason that they're saying they want to join is so that they can learn and help others fight learn how to fight foreclosure. I'm like, yeah, right. So we've already established that the conventional foreclosure strategies were structured by the same attorneys that's stealing your property. So in my opinion, anytime you're doing anything inside of the conventional foreclosure way, you might as well just kind of hang it out, because you're going to get hosed in the end, because that whole process is set up to help the bar members take advantage of the homeowners. I have 1 or 2 haters that have been following me around. One of them found my Google review page and left a bad review, even though he never invested in my program. And it's kind of interesting. We must be doing something right up in here if these people are trying to join my page and these people are leaving bad reviews and talking crap on me in other groups. And those same people that's talking crap are trying to join my group, our group, okay? Go figure that. So if you're ready to stop wasting time, reach out to me and let's get this ball rolling. Advocates for Justice Paralegal Service. We are different and we prove it. Thank you. Have a great day.